Please welcome GSAR President Andy Azzarello for our Raising the Bar #2 / legal update class with Anthony Gatto. He is NYSAR's attorney on staff. And Andy, go ahead, take it away.
Well, since Danielle just took away 3/4 of my speech, this is going to be really quick and easy. Welcome to Raising the Bar #2 with Anthony Gatto. Please make sure you sign into the chat box to get credit. Make sure it's your first and last name, full first and last name. We've had a few that were just somebody plus iPad, and I don't think anyone's last name is iPad. So we want to make sure everyone gets full credit for being attending. Today, you can also receive 1 hour of free CE and also credit towards qualifying of the 20% local dues discount in 2023. Make sure that your camera stays on at all times. If you're having problems, like I heard some are, just make sure Danielle knows in the chat box so she can keep track of that. But cameras all should be on. Also, there is a poll at the end of the whole seminar to make sure you participate in that as well in order to get the CE credit as well. Remain on mute the whole time so we prevent the feedback and all that as well. If you have questions, we got the chat, and I believe at the end, right, Danielle, there'll be time to ask questions if it's not in a chat. We're going to break it up throughout the segments with Anthony, and he'll answer questions after each section and then at the end as well. We want to thank Salve Bank as the sponsor for Raising the Bar. We have Trish Cazzoli with us today, and Trish, it's all yours.
Hello, everyone. My name is Trish Cazzoli. I'm a loan officer here with Salve Bank, and being a silver sponsor, we were given a minute or two just to introduce ourselves and just to let you know some of new upcoming programs that you might want to be interested in. One of the big items that is coming up on May 27th that might roll out around the 22nd is the DREAM program. So if you have any first-time home buyers that are short cash, it is income driven. They are awarding $9,500 to help them with their closing costs and down payment. This is free money, basically. You have to live in the home for 5 years and it's totally forgiven. If they sell their home in less than 5 years, that's still okay. It's going to be prorated. So they'll owe a portion of that money back to the Federal Home Loan Bank. So that is going to be coming out in the next 3 weeks. So if you have anyone, let us know. The income is pretty good for a 1 to 2 person household. You can't make more than $68,080 a year. So, but I heard that they're going to be increasing that income limit because what's going on in the market with the higher prices that are, selling out there. So please keep that in mind. And then the only other program I want you to let you know is new construction. If you do a lot of new construction, because of COVID and what's going, a lot of the builders and suppliers are behind, we're protecting people's interest rate for a full year. So there's not going to be any issues with the rates. Now that the rates are starting to inch up, we're going to protect the rate for a year so they don't have to worry about getting a higher rate or paying extension fees. So those are probably the 2 biggest items that, I want you to know about. So does anyone, have any questions? You can feel free to email me or call me. I believe my email, I don't know if my email address shows up, but it's pretty simple, tcazzoli@salvebank.com. Okay, and thank you for having me this afternoon.
Thank you, Trish.
Thanks, Trish.
Okay, thank you. Have a nice meeting.
Christine.
Okay, we'll turn it over then at this point to Anthony Gatto so he can go over the 2022 legal update.
Thank you, and good afternoon, everyone. Just to reiterate the fact, as far as we're getting CE for this, the state has been more than accommodating in giving us permission to do virtual CE courses. Please remember that your camera must be on and your name must appear on your video so that the association can give you CE credit. If you don't appear on video and your name's not there, you will not be getting credit. So we do the same thing here at NYSAR, so I'm used to it. Okay, I'm going to share my screen. Okay, there we are. Also stopping my video because you don't want to see me, you want to see the slide. So good afternoon, welcome to March, right? I mean, spring is a couple of weeks away. It's kind of an uplifting thing, I guess, after all we've been through the past couple of years. So looking forward to a spring and summer that we have a little bit more freedom, I think will liven all of our spirits. And I don't know, for those of you who are at the business meetings at the Desmond a few weeks ago, it was welcome to see everyone in person rather than them on Zoom. So I do welcome us getting back to some degree of normalcy. Okay, so one of the benefits you have of being a member of NYSAR is that you are have access to the NYSAR's legal hotline. The legal hotline is available Monday through Friday from 9 to 4 at 518-436-9727 or 518-43-NYSAR. You will get either my associate Liz or myself on the phone. You can ask any questions related to your licensed activities. We cannot answer any questions related to the rights, liabilities, or obligations of consumers, which means buyers, sellers, tenants, or landlords. If there's an attorney on the phone, you'll get a voicemail during operating hours, and then we will call you back by the end of this business day. So that is free for you to utilize. On top of the free legal hotline, NYSAR is also offering a free monthly CE course as a legal update. You can register for that for credit once every 2 years during your license renewal period. We also record it and live stream it for those of you who don't want to get CE credit for it, but it does also count towards the 1 hour of legal update that you're getting today. Just so you know, you can take more than 1 hour of legal update and it would just count toward your general CE credits, not part of the core once you get that satisfied. So you can take it or take a legal update more than once, but not the same legal update, obviously. Future dates coming up all the way through the end of December. We have them once a month. Our limit is 200 persons per session. You can go to NYSAR.com to log in, go to the education section and choose the NYSAR course schedule, or under education, choose the NYSAR legal CE course, and then you can register for that as well. So the first topic we're talking about today is homeowners insurance, and it has to do with dog breeds. And many people ask, well, why are you doing this? Well, because, you know, there's actually a significant fair housing component to this that was being utilized by some landlords so as not to take service animals. So the legislature passed a law preventing insurance companies from doing anything about dog breeds. So under the new insurance law section, no homeowners insurance company shall refuse to issue or renew, cancel or charge or impose increased premiums or rates based solely upon harboring or owning any dog of a specific breed or mixture of breeds. So I think we've seen this before where those of you who do rentals, some homeowners insurance companies won't cover a property if there's a pit bull in it. Pit bull is the most common breed that they've been excluding. That ran into some issues in fair housing because you had an individual who needed a service animal, and their service animal happened to be a pit bull, and the landlords are saying, well, I can't take you because if I take you, they're going to cancel my insurance. Now, there's two layers of liability that go there. One with the homeowner for denying a service animal because there's no justification to do so. And two, you know, are the insurance companies themselves violating fair housing laws by not providing the same level of service to everyone, especially those individuals who have service dogs that happen to be one of those dangerous breeds, according to the insurance companies. So the legislature changed that to tell insurance companies you can no longer restrict based on dog breed, and you can't charge anything more for it either, whether it be just a regular pet or a service animal. So I've had this question the first time I brought this up, but are dogs a protected class now? In my house, they are. Okay, they run the house. But in real life, no, dogs are not a protected animal. Neither are owners. However, owners who have service animals are protected under that, as far as the disability is concerned, under fair housing. And like I said before, some landlords were refusing accommodations based on the fact that their homeowners insurance could be canceled or rates could be increased. And as you know, landlords are prohibited from charging extra money if someone has a service animal. So even if the insurance company raised their rates, the landlord would not be able to recoup that money from the individual with the service animal. So landlords were kind of stuck between a rock and a hard place, in my opinion. Like I said before, insurance companies were slow to change those policies, even though they were notified that there could be fair housing violations. So again, the legislature took it into their own hands and did it, which I think was a commendable thing to do. So what can landlords do now? Well, they can still have no pet policies. Just because their homeowners insurance company can't cancel or charge them more money if they have a dangerous breed, it doesn't mean that the landlords have to accept pets or have to accept these certain breeds, obviously except in the case of a service animal. Landlords can still say no pets. They can say only cats, no dogs. They can say pets under a certain weight threshold, which my pets have never been under 20 pounds, maybe at birth, and that's about it. But once my wife starts giving them treats, that 20 pounds goes out the door fast. So landlords still do have a right, but again, with the service animal, they would not, and they don't have an excuse anymore as far as the insurance policy is concerned. Anybody have any questions about this policy, this matter? No? Okay. A good segue into fair housing. The new fair housing laws, as you know, as a result of the Newsday investigation on Long Island, there was a Senate hearing pertaining to discrimination, the sale or rental of real property. If any of you happen to have watched all 6 to 8 hours of that Senate hearing, you would see exactly why they're passing this slate of bills into law. Just because, you know, sometimes you just hear someone testify and you shake your head and you wonder, you know, where's the cane to pull them off the side of the stage so they stop saying things. But a lot of the licensees who testified at the Senate hearing more or less shot themselves in the foot. But it didn't look good for us as an industry. And as a result of that, the state passed a number of new laws pertaining to fair housing. The first one, which is in effect today, actually was in effect effective December 21st, requires any office manager must be an associate broker, and they must have been an associate broker for at least 2 of the previous 4 years prior to being appointed as an office manager. So that means that someone's got somebody needs to mute. There we go. So it's not the newest associate broker being the office manager. That's really not the position office manager is supposed to do. They have almost the same duties as a broker does as far as duty of supervision is concerned. So having your newest person be the office manager is usually not the smartest thing to do. You want someone who's more experienced. And this, again, sets the stage for someone to be at least associate broker for 2 years before they are named office manager. If an associate broker was already an office manager before December 21st, they would be grandfathered in. So if you had an office manager with less than 2 years experience who was appointed office manager prior to December 21st, 2021, they would be exempt from the requirement of 2 years. But anyone who was named office manager after that would need to have at least the associate broker with 2 years experience. And again, this is just raising the bar. One of the things the senators saw during that hearings was that there was no supervision in certain offices. There were brokers who had hundreds and hundreds and hundreds of licensees and no one to supervise them but that broker. That's that broker's choice as far as their business model is concerned. But the Department of State wanted to make sure that brokers who did utilize office managers were utilizing an experienced licensee, not someone who was new. The second one is kind of funny. This is requires the state to establish a telephone hotline for housing discrimination complaints. So if someone's discriminated against, they can contact the state and file a complaint. The bill was signed into law. It will go into effect on April 20th. Insert 420 joke here. But all joking aside, it is again a bill related to fair housing. The funny thing is, if you look at the housing and anti-discrimination disclosure form that you're required to give consumers at first substantive contact, it has a fair housing hotline on it that's already been established by the state. So again, this is just a cut and paste off that housing and anti-discrimination disclosure form, which already has the fair housing hotline. I hope the state keeps the same phone number because this document is in circulation. It's been given to tens of thousands of consumers by licensees. So I hope that they keep the same hotline, but it's just funny they pass a law to establish something that's already in place. But this is another one of the things that they did in their bills. We're going to have more CE to do. Your 22 and a half hours is not going to change at this time. It's still only 22 and a half hours, but the state is including 2 hours of implicit bias education for real estate licensees. There was an issue with the initial bill. The effective date was much too short. There's a lot that has to go into drafting new courses and getting them approved and then out to you as licensees to teach. So having a very short effective date was not something that was going to work. The new law is going to be effective September 21st. But this is what's called a chapter amendment. So the governor last year signed this bill saying, I agree to this bill only if the legislature goes back and changes a part of it, which was the effective date. So, excuse me. This is the amendment is to change the effective date to September 21st, 2022. I can tell you that NYSAR already has courses lined up. Once the chapter amendment is passed by the legislature and signed by the governor, for us to submit those to the Department of State for approval, and we will be offering those just as soon as everything becomes effective. But if your license expires on or after September 21st, 2022, you will need to complete the 2 hours of implicit bias before that renewal. Again, we have a time lag issue. The course is being developed. So we will be working on that and keeping you updated. There's another addition to your CE. Again, the 22 and a half doesn't change, but you're also going to have to take 2 hours of cultural competency education. This bill, again, was signed last year by the governor. However, the governor signed it with the provisions of having a chapter amendment, one about the effective date, and secondly, because there was no definition of cultural competency. So trying to write a course where there's no definition or guidance is difficult for anyone who's ever had to write a real estate course before. So again, this is going to be effective September 21st, 2022. And again, they provide a definition of understanding cultural norms, preferences, and challenges within our diverse community. So you're going to have 4 more what I'm calling core requirements in your CE after September 21st, 2022. If you recall, currently you have to take 3 hours of fair housing. You have to take 2.5 hours of ethical business practices. You have to take 1 hour of legal update, which we're doing today, and then 1 hour of agency, unless it's your first renewal period, then you have to take 2. On top of that, now we're going to have 2 hours of implicit bias and 2 hours of cultural competency, which would give you 11.5 hours of core requirements, and then 10.5 hours of what I call electives or other CE courses you may want to take that aren't required as part of that core. And again, the same thing, cultural competency as applies to implicit bias. We need to develop the courses, get them approved by the department, and get them out there for you to take so you can have those if your license expires on or after September 21st. So this next bill, or law that was passed last year by the governor, is also subject to a chapter amendment. And one of the things that they found during the Senate hearings was that there was so much disparity between policies and procedures within the same brokerage as far as the manner in which buyers are treated. As a result of that, the legislature introduced this bill that was signed by the governor that requires all brokerages to draft a standard operating procedure regarding how they treat buyers. So most of this, the bill itself talks about whether or not the broker is going to require pre-qualification letters from buyers, whether or not the broker is going to require buyers to provide a copy of their ID prior to taking them out. And I can tell you, there were quite a few of the licensees who were investigated who, with the minority tester, they required a pre-qual letter, and with the white testers, they did not. And it was very obvious. There wasn't, an exception. So the legislature found that it would be in the best interest of all for brokers to have office policies. Now, the law also requires the Department of State to draft rules and regulations to help to guide licensees about what's required to be in the standard operating procedure. The State Board of Real Estate just formed a subcommittee the other day to draft model regulations. Once drafted, they will have to be put into the state register with a 60-day comment period. And only after the expiration of the 60 days could those regulations become effective. So even though we have an April 20th effective date on this, I don't think that the regulations are going to be promulgated and adopted by that point. So while the department, while the law may be effective, the Department of State would not be able to provide guidance or enforce the matter on April 20th. So we will have more information as those dates draw closer. One of the issues we had with this bill in particular when it was first drafted was that it required all the brokers to write an SOP and then send it to the Department of State. The department was kind of in shock because they don't have the resources to collect all of these SOPs and then put them in storage and checking them to make sure all brokers are in compliance. So there's been some tweaks to that. We already talked about this. So instead of having to do that, NYSAR suggested that why can't the broker just check off on the box and renew their license that the broker has an SOP in compliance with this law? And the Department of State said yes, and the legislatures agree with that. But they added a few more twists to it. They must have a date stamped, notarized, and they have to post the SOPs in any public websites or mobile apps. If requested by a consumer, they have to provide a copy of it at office locations. Since advertising is only done by a broker and the broker authorizes licensees within their office to conduct advertisements, advertisements done by associate brokers, salespersons, or teams on the web or their websites would also have to have a link to the SOPs, much the same that is required for the New York State housing and anti-discrimination notice that's required as well. If the broker alters their SOPs, that has to be time-stamped and notarized within 30 days and then archived by the broker. And again, the broker would just check off a checkbox on the renewal form that they are in compliance. Now, there's a lot of nuances to this. For instance, a broker, so here's kind of the things you're talking about, whether ID needs to be shown, whether there's an exclusive broker agreement or a buyer broker agreement, exclusive right to represent, whether there's any pre-approval, and then number 4 is the DOS matters. We are going to try to provide comments to the Department of State when they draft these to carve out exceptions. So let's say ABC Realty's broker says, I don't want my licensees, I'm not going to make my licensees get identification from all individuals who come in the office. But, you have some licensees who want to do that for security purposes, right? Anyone who's taken NYSAR's recent safety courses, we talk about getting proof of identification for individuals so you know who you're going out with. We will try to get the department to allow that to be done. If the broker doesn't do it on a full brokerage basis, that licensees could do it individually. But in that case, the licensee would have to do it for each and every person that they come into contact with. They can't just pick and choose. Again, universal applications of policies and procedures are the best way to prevent yourself from getting in trouble for violating fair housing. So these are things we'll be discussing with the state. But again, this is not in effect yet, but it will be. Okay.
Anthony,
Next,
would a driver's license qualify for that? Copy of it?
whatever the broker is comfortable accepting, or whatever you're comfortable accepting. Okay, they're adding more education to the pre-licensing course for brokers and salespersons. That is just adding extra hours into the fair housing training, just so they have more fair housing training at the onset of their career, rather than having to wait a few years here and there to take CE courses. The other part of this bill was that instructors, if you watch the Newsday investigation, the Senate hearing, they found that many of the instructors were not complying with the requirements as far as teaching fair housing is concerned. There's 3 hours. Many of them weren't teaching 3 hours. Many of them were saying things that were alleged to be inappropriate during these courses. So they want to put more responsibility on the instructors to make sure they're teaching what they're supposed to teach. So the instructor would have to sign an oath of compliance that, when they taught the course on 3 hours of fair housing, that they stuck to the outline and that they did it for the time allotted, et cetera. So kind of adding an extra layer of responsibility on the instructors. I can tell you that instructors always had this responsibility. This is nothing new. It's just that some instructors came to the forefront through the Newsday investigation to show that there were deficiencies in the instruction process. So they want to hold instructors more accountable. But I think they always had this power, to be honest. They're just putting it into law. So, and this will be effective in December of 2022. So you will notice your license fees are going to go up. They're going to go up $30 for brokers and $10 for salespersons. This extra money is going into a fund. That fund will be used to do paired testing throughout the state of New York to try to identify discrimination in the sale or rental of real property. It was difficult for NYSAR to try to oppose this, other than the $5 fee that was added on quite a few years ago. So you can get your pocket card that looks like a New York State driver's license. The fees for brokers and salespersons license hasn't been changed since the mid to early 80s. So it was difficult for us to say that you keep increasing it when it's been 30 years and no one's touched it. So inflation hit, but regardless, it's for a great cause. I don't think anyone who's on this call today or on the Zoom meeting today wants to see our peers discriminating against individuals. It gives us all a bad name. I think we're still recovering from the Newsday investigation. That's just what's happening. So again, using this as for pair testers to go out and test the licensees and to test apartment complexes, not just real estate licensees. It's going to go after large apartment complexes that hire their own leasing agents. So it's going to be all encompassing as far as that's concerned. The next bill that was passed raises the maximum fine for real estate licensees from $1,000 to $2,000. Those fees will now be put into the same fund as the increased license fee to use for pair testing. There's a little bit of resistance to this, which I thought was kind of funny. The only way you're going to be subject to this is the Department of State finds that you violated the license law in some way. So hopefully 99% of us will never have to deal with this. But I don't think that the increase in fines was that egregious. And again, it's only going to apply to those individuals who are found to have violated New York State licensing law. And that is effective today. This is just one that requires local and state agencies who administer any kind of housing programs to advocate for fair housing, which I think most of them already do. But again, just it looks a lot better if it's in law, right? So this is just telling agencies to advocate for fair housing, and then to provide every 5 years, they'll be looking at it to see whether it has to be amended or what else can be done. As much as we try to advocate for fair housing, I believe that state and local government should be doing the same thing as well. So as far as, I want to go back to the SOPs quick. So the SOP bill, when it's in its final form and when the regulations have been passed, NYSAR will be providing sample forms as well as an educational component for brokers to know how to fill them out and what to do with them. So please don't feel that you'll be on your own. All of these, when they go into their final form, NYSAR will be providing an educational component to them. So we will be following up on all of these. There's a lot of resources you have for fair housing. NYSAR.com is a fair housing page. NAR has got a fair housing page. The state has many fair housing pages. So does the federal government through HUD.gov. DOS has a fair housing page, and DHR has a fair housing page. If you haven't gone to the DHR fair housing page, you really should. The link is also available on NYSAR.com to the DHR page. They have a lot of great information on fair housing. They have a lot of good guides about different types of fair housing violations, such as lawful source of income. They also have a link to their YouTube page, which I never realized they had a YouTube page. And the YouTube page is interesting because it comments directly on issues related to discrimination, including discrimination in housing. And the individuals speaking on that are normally employees of the state. In some cases, it's the General Counsel for the Division of Human Rights, Carolyn Downey. Now, while you can sit here today and I can tell you what you should and shouldn't be doing, this slide deck will be available to you after the presentation as well. So don't feel that you have to. I see everybody scribbling down web addresses. I'll send this to them and they can give it to you. I can tell you what's legal and what's not, but you know what? Even in my position, I watched all the videos on the DHR page. Why did I do that? Because if DHR is telling you something's a violation or something may be amiss, that's who I want to hear it from, right? I want to hear it from the source. These are the people who make the determinations on what's a violation of New York State human rights law, or what's deemed to be discriminatory. And if they say something's discriminatory, well, I will take that as gospel that it's discriminatory. So if you have time, go watch the DHR YouTube page. It's really interesting. They have a lot of good things on there and some pretty decent discussions. Okay, we are all members of the National Association of Realtors. We all abide by the Code of Ethics and agree to behave ourselves. But, from time to time, the Code of Ethics change, and there's some changes to it this time around. The first change is the Standard of Practice 1-8. And if you remember a few years ago, they changed Standard Practice 1-7 that would require a listing broker, if they were provided with a request by the cooperating broker, to affirm the fact that they gave the offer to the sellers. And that was under 1-7. So at the time of submitting an offer, a buyer's agent could put a request into the listing broker, that the listing broker sign the fact that they actually gave the offer to the sellers, and then the listing broker returns that document to the buyer's agent. Again, it only applies to the listing broker. We cannot compel the seller to sign it. It is not a violation if the seller doesn't sign it. Again, the National Association of Realtors only has control over our members. So it's up to the listing broker to affirm the fact that, yes, I did give the purchase offer to the sellers, and then deliver that back to the buyer's agent. So what 1-8 does, it builds off 1-7 a little bit, and it requires the same thing if a listing agent is giving a counter offer back to the buyer. So the offer is made to the listing agent. Let's say it's a multiple offer scenario, and then the listing agent responds with a counter offer to the buyer's agent. The listing agent can provide a similar form to the buyer's agent, saying that the buyer's agent would affirm that they presented the counter offer to the buyers. Now, if it turns out that they don't, then that individual is putting their not only their membership in the realtor organization in jeopardy, but also subjecting themselves to potential liability from the Department of State. I don't know if this is an issue. I really haven't heard of any issues in the counters. I've heard them in the presentation of initial offers. I haven't heard of any issues of buyer's agents not presenting counters to their clients, but apparently it's an issue enough that they changed the code of ethics to include this. So this is just going to be another similar form to the one for 1-7. Standard of practice 12-1 has also been amended. This is we used to be able to advertise your services for free. This was commonly done with buyer's agents because they were being compensated by the listing agent. So technically the buyer wasn't paying the buyer's agent anything, but that was not technically free. So now under the new provision of the Code of Ethics, free means free. Free means that if you're advertising your services as free, you are not being compensated by anyone or any party. You are working for free. I don't know if that's a sustainable business model. I think you need some kind of income coming in in order to survive, but you can't offer your services for free unless they are truly free, and you'll receive no compensation of any kind from anyone or anything of monetary value. So it's not just cash. It could be gift cards or something else of monetary value. So that's the other change. This is all in response to the DOJ agreement that NAR had that was then the DOJ took it back, but NAR continued through with some of the changes, again, just to have more transparency in our industry. So the Code of Ethics has a number of articles in it. Within those articles are standards of practice. For instance, Article 1 we had before, and under that is standard of practice 1-8 and 1-7. Article 10 has to do with discrimination. Recently, it was amended to include social media issues. But in order to help hearing panels and you as members of a professional standards committee understand more about the specific standard of practice, NAR issues what's called case interpretations, where they give kind of like a mock case as to the application of certain provisions of the Code of Ethics. In this case, it's case interpretation 10-11. The fact pattern was that a listing broker took pictures of a property. Within those pictures were a depiction of the Confederate flag. A complaint was filed against that broker for dissemination of the pictures with the Confederate flag in it. The hearing panel concluded that whether the broker's inclusion of the Confederate flag was intentional or not, it could be construed as indicating a racial preference or some type of discrimination based on a protected class, and was found to be a violation of Article 10 based on standard of practice 10-3 and 10-5. Now, I'd like to say I've never heard of this before, but I have. I think it was someone out in your area as well, maybe about 10 years ago, called me where they were going to a listing. They were taking pictures. Down in the basement was a room in the basement. That room was full of Nazi paraphernalia. Everything from helmets, guns, flags. It was plastered wall to wall with like I said, Nazi paraphernalia. The listing broker didn't feel comfortable taking pictures of that room for people or showing the property to individuals, because I think that also could be deemed to be some type of racial preference or discrimination. So the same thing holds true now. So if you were to have a listing where there was some type of hate symbol, you should not be taking pictures of that and including it as part of the listing. If you want to take a different angle, if you want to, if you're the least bit competent in Adobe, you can cross it off and redact it so no one can see it. But the display of such information of hate symbols would be a violation of the Code of Ethics. So springboarding off of that, just this year, the state of New York passed a new law for public buildings. This only applies to the state of New York. It doesn't apply to consumers, doesn't apply to private businesses. But the state is now prohibiting the state or any state entity to display any symbol of hate, or to sell any symbol of hate with government buildings, museums, etc. They call symbols of hate include the symbols of white supremacy, neo-Nazi ideology, or the battle flag of the Republic. There are other ones, obviously, as they become adopted or people are made aware of them. This only applies to the state of New York. So the state itself can't produce or display these symbols of hate in any governmental building. But again, it does not apply to private residents or private businesses. So it kind of goes hand in hand with the case interpretation for 10-11, but it just to show that it's not just NAR that's making these determinations. Our own national or our own state of New York is trying to keep the state out of such business. I'm unable to tell you whether or not certain symbols of hate would be permitted. I know that the swastika was adopted by the Nazis, but prior to being adopted by the Nazis, the swastika was revered by many different cultures as being a symbol of luck and good fortune. Individuals who still practice with that, I don't believe it would be in violation, but we don't know yet. I guess the same thing, if you think about things, prior to the Nazis, the swastika was not associated with the Nazis. Prior to certain things, the OK symbol was not deemed to be a symbol of white power until these organizations or entities adopt them to have some type of discriminatory appeal to them. Okay. Any questions about those things before I move on to the next?
And we do have some questions. So I'm going to start. There's, I think, 3 or 4 of them. So I'm going to start with the first one and then move down into the other ones. But the first one was, will these laws, regulations, fees be expected to be expanded to all parties in the real estate process? Loan officers, attorneys, HUD employees, or similar, home inspectors, etc.
They are part of the real property law under Article 12A, so they only apply to licensees at this point. I can tell you that many of them also apply to other actors as well, but they're just codifying this into law as far as licensees are concerned.
The next couple questions have to do with what you were just talking about. Is the seller required to remove those items for showings as well?
The answer to that is no, they are not required to remove them. However, as a listing agent, you're going to kind of be put into an awkward position, I guess might be the best way to put it, right? We're going to have uncomfortable conversations. Do you want to advise the buyer's agents going in that there's a Nazi room in the basement, right? I mean, is that something that may be offensive to individuals coming in? Or there's a room dedicated to the Confederacy with Confederate battle flags and whatnot in them. So while the seller is not prohibited from doing it, it's their First Amendment right of free speech. They can do whatever they want. I think we as licensees have to be aware of sensitivities some individuals may have if they were to enter that home and see those symbols of hate. So while no, they don't have to do it, I think you just have to be extra vigilant if you do have a listing that has these items.
I think that'll tie into this next question then. If the seller refuses to remove these items, should we make a note in the private comments?
I don't see why you can't, so long as you tell the seller you're doing it. Again, you still owe them fiduciary duties. There's nothing illegal about what they're doing, so you're not carrying out an illegal directive from the seller. But you just have to let them know that, hey, listen, and here's the possibilities, and I would take that route if I were a licensee and the seller did have those things in their property.
Okay. The next question is regarding the Confederate flag discussion. If the seller leaves it up in the house for showings, can agents be charged with a fair housing violation if buyers complain?
I think that would be a stretch. Again, I think if you were to do like in the prior remarks saying, the property contains whatever it happens, Confederate flag, Nazis, paraphernalia, whatever. I think you're protecting yourself. Again, the seller has the right to the First Amendment right of free speech. They can display a Confederate flag. They can display a swastika if they want to. But you will not be liable just for the display of that material. If they went a little bit further and perhaps had a sign identifying a protected class and saying, Fraggles go home or no Fraggles permitted here, I think that would be problematic if the licensee knew that it was up there. But I think just the general display of those materials would not subject the licensee to any liability.
Thank you. And then the last question that I see in the chat is, can we ask sellers to remove discriminatory items from view during the showings?
You can ask them anything you want to. Whether or not they're going to do it's another story, right? Not all of our sellers are cooperative with us. You can ask, if you want to protect yourself, if you're worried about some type of liability somewhere down the road, put it in an email, right? Hey, dear Mr. and Mrs. Smith, in viewing your property, I noticed that there's a room full of Nazi paraphernalia in the basement. I would recommend removing such paraphernalia so as not to, and then talk about protected classes and things like that. So you could cover yourself. Again, the more you tell them, the better off you are going to be.
Thank you. And then Sarah Jefferson has a question, but it's not typed out in the chat. So Sarah, if you would like to ask your question.
Yes, I would. It was my understanding that if you go in with someone and they say, well, I don't necessarily want someone of a Hispanic nature or a Black nature, you're to say, I'm sorry, I have no option to say that I'm not going to show your property to anybody who calls me that wants to see it and can in fact afford it. And they say, I don't want that. And then you can go ahead and say, well, then I'm sorry, I can't represent you. However, this just sounds like a roundabout way of not selling to a protected class. Put something in the house that lets them know what kind of area they're going to be moving into. They're going to move on.
Correct, but there's still, again, that seller still has the right under the First Amendment to display those materials. Could that turn into a lawsuit? Yeah, it could. Sure, somewhere down the road it could be. They can go after the seller saying, you intentionally displayed Confederate flags to have a certain protected class not want to live there, or Nazi paraphernalia, or whatever it happens to be, white power symbols or anti LGBTQI plus stuff. I mean, the list goes on and on. But yeah, I mean, I think that could be, but I don't think as a licensee you would be liable unless there was something directly saying that they don't want this protected class.
Okay. Now, would you be obligated to contact fair housing or no, because of confidentiality?
I don't think it's a fair housing violation unless, like I said, there was something directly, like we don't want Fraggles go home, and then confidentiality goes out the door, right? Because your fiduciary duties only apply to a legal directive, right? This would be something illegal that the sellers are doing. Okay.
Thank you.
Sure. We good, Danielle? Oh,
Yes, sorry, I was muted. No, there are no more questions in the chat that I see.
So the next section is amendments to the Tenant Protection Act. I know you have a lot of waterfront properties out in your area. I'm sure seasonal rentals are very popular. If you remember, the Tenant Protection Act was passed a couple of years ago. What it did, it prohibited landlords from collecting a security deposit greater than the first month's rent, and they could not accept any advances on rent except for the first month's rent. So the old policy of security deposit, first month's rent, last month's rent is out the window. security deposit and first month's rent only. You cannot collect the last month's rent because that's an advance on rent. Someone wants to rent a lake house in your area and they want to rent it for the whole summer, right? They want to rent it from June 1st until Labor Day. Under the Tenant Protection Act, that landlord couldn't just take a lump sum for those 3 months because you can't collect anything greater than 1 month's rent at the onset of the relationship. Likewise, you couldn't accept a security deposit greater than that 1 month's rent. So hypothetically, it's $30,000 to rent the cottage on the lake for the summer. At the onset, the landlord could collect $10,000 security deposit, $10,000, which is the first month's rent, and that's it. And then 30 days later, they collect another 10 for the second month's rent, and then 30 days later, they collect another 10. Maybe not so much in Syracuse, but down in the Hamptons, when you're renting these properties, there may be a piece of furniture or a piece of artwork that's worth more than the full month's rent. So landlords down there were getting worried because if they can't collect a larger security deposit because of the furnishings in the home or whatever the home happens to be, it was problematic for them. So the legislature took action and amended it only as it relates to seasonal use dwelling units. That's what they're defining these as. So I call them lake houses and ski chalets, right? That's probably the two biggest long-term kind of seasonal rentals you're going to see. In order to qualify as a seasonal use dwelling unit, you have to have a seasonal use dwelling unit registry. That's going to be done at a local level by law. If you don't meet all the requirements under the SUDO, I'll call it SUDO, you don't get the exemption and the Tenant Protection Act applies. So to qualify as a SUDO, you have to have a provision within the lease stating that the dwelling is a registered seasonal use dwelling unit and where it's registered, whether it be the town, county, village, whatever it happens to be. That the occupancy of that tenant is only for seasonal use, not to exceed 120 days or less. And the tenant has some place to return to, and that address is listed in the lease. They have a primary residence to return to. Not only that, the seasonal use dwelling unit exemption is only good for 120 days per calendar year. So for instance, where I am in the Albany area, we have the Adirondacks to the north of us, and we have lakes and we have mountains. Some people have summer cabins that also double as winter ski chalets. That landlord, if they wanted to rent it out for the full ski season and the full summer season, would have to choose one or the other. They only have 120 days max per year to claim this seasonal use dwelling unit exemption. So they would have to choose either summer or winter to get that exemption. The other one would follow under the normal Tenant Protection Act. Your local government would have to pass a law permitting seasonal use dwelling units and then create that registry, like I mentioned before, as well as other requirements they may happen to have. One of those includes that you have to file the lease, and that lease again has to contain provisions that it's a seasonal use dwelling unit. The renter has someplace else to go after the 120 days or less are up. And any other the requirements on that. So you do have to file the lease with them as well. If there's no local, county, or state registry, the property remains subject to the Tenant Protection Act and would not be able to claim the exemption. Now, the law states county, local, county, or state. I can tell you today, as I sit here, there's a 99.999% chance the state is not going to create a registry. They don't need this kind of headache and paperwork. So it's going to be done on a local level. So if you as a licensee are listing a property for seasonal use and the landlord tells you, I want you to collect 2 months security deposit and the full amount up front, you have an obligation to make sure that that is registered as a seasonal use dwelling unit. You cannot just take the landlord or owner's word for it. You would have to go check with your municipality to make sure that that property is in fact registered. And then you have to make sure the lease is in compliance. So there's a couple things you have to do. If it's not registered and you are collecting more than 1 month's rent or a security deposit greater than 1 month's rent, you could be held liable for violating the Tenant Protection Act. And, this is really no different than your current obligations to investigate the legality of a rental. If a landlord comes to you and wants to rent a unit, you have an obligation to make sure that's a legal unit to rent. You have to make sure that the CO permits it to be a 2-family, or that if there's a rental permitting mechanism in your locality where you have to get a rental permit or inspection prior to rentals, that those have been done. That's your responsibility as a licensee. You cannot just take the seller or landlord's word for it. So like I said, there's no New York State registry, and I really doubt there's ever going to be one. This is a great cause for local boards to take up and advocate to your localities if you do live in an area where there are seasonal rentals. And I know that, like I said, you have a lot of lakes and waterfront property out where you are, so I'm sure that it does occur. It would be good to organize maybe with your local board and advocate with those localities to pass a seasonal use dwelling unit law to permit that, so that you don't get stuck with the Tenant Protection Act. I mentioned previously, many municipalities have some type of rental mechanism in place or rental process or procedure. Either a rentable occupancy permit or some type of inspection has to be done, or some type of registration of those rentals with the municipality. If they already have that, same thing holds with, like, sometimes they have short-term rental laws as well. Some municipalities do. This would be a great add-on to that. So you don't have to start from scratch and square one, trying to draft a law and where it's going to fit in to permit seasonal use dwelling units. So they already have these rental laws in place. It would just be an add-on to that. I think it's very simple. And for those municipalities who garner a significant amount of tax revenue from these seasonal units, I think they would welcome them. I know that there are other municipalities that hate people renting seasonally or renting weekly or monthly, whatever it happens to be, but other ones take it with open arms because it's more money coming in. I mean, if I owned a summer camp, and I just stay there all summer, I would spend a lot less money than the people if I rented it out to someone every couple of weeks or so. People go on vacation, they spend money. So those municipalities and localities do get some benefit from it. Okay, we'll do a few more minutes since we started late. I want to talk about a couple of court and DOS decisions. This is an interesting one. This is a fair housing case taken on by the Department of State. This happened downstate. This is an open listing for a rental. The individual who was interested in renting the property was a foreign diplomat. That foreign diplomat had a representative who was communicating with the licensee on behalf of the diplomat. During discussions with the listing agent or the agent representing the landlord, the representative disclosed the fact that the tenant was a diplomat. The licensee asked, what country is the individual diplomat from? I see some of you already shaking your heads. Good. The tenant responded with the country, which I think was Malaysia, if I'm not mistaken, that the individual was a diplomat from Malaysia. So the licensee then advised the tenant that the building management did not accept diplomats from Malaysia as tenants. Oh boy, your words can get you in trouble. The licensee also used titles such as licensed real estate agent and leasing director. As you know, you can only use the title that appears on your license, licensed real estate broker, licensed associate real estate broker, or licensed real estate salesperson. These titles are not permitted, so that's another no-no. So the DOS found that the licensee violated both fair housing and New York State human rights law by saying that the management company would not accept diplomats from a certain country. DOS also found them in violation of using improper titles. The broker of the brokerage was also found to be liable for failing to supervise their licensees. All brokers have a duty to supervise, and sometimes those brokers get brought into DOS hearings because of the failure to supervise. The Department of State, in their discipline, revoked the license of the broker and the licensee. This is significant because if the broker's license gets revoked and they're the only broker for that brokerage, guess what happens to the brokerage? They close. They don't have a broker to operate anymore. So all the licensees under that broker could be out of a job, so to speak, or out of their independent contractor relationship, would have to find another firm to work for. Here's the twist on this one, and this is why it's kind of interesting. The licensee called the management company and said, we have a diplomat from Malaysia. The management company told the licensee, we don't rent to diplomats. That's all the management company told the licensee. The licensee then conveyed that to the potential tenant, saying, the management company doesn't rent to diplomats from Malaysia. If they had left off from Malaysia and just said the landlord doesn't rent to diplomats, that would be okay, because you're not discriminating based on country of origin. Not all diplomats are from different countries. There are many American citizens who work as diplomats, both for foreign countries and for the UN. So it's not just individuals who come from different countries. So again, if the landlord just said, we don't rent to diplomats, and the licensee said, well, the landlord doesn't rent to diplomats, we wouldn't be having this conversation right now. It would not be a violation of fair housing. The reason why landlords are going to do that is because diplomats have immunity, diplomatic immunity, which means that if the tenant took off and didn't pay rent for 6 months, that landlord can't go after them for it. And even in these situations, some landlords try to get them to try to get the tenant to sign personally, not on behalf of the country they represent, and they just won't do that. So again, the licensee added something they didn't have to add. It was never told to them country specific, but because they added from Malaysia to the statement they made to the tenant, they lost their license. I will tell you, in most cases involving violations of discrimination or allegations of discrimination in the sale or rental of real property, the DOS is going to go after your license first. That's what they're going to try to do, and rightly so in many situations. And again, like I said before, the decision noted the building didn't rent to any diplomats, not just ones from Malaysia. So that was problematic. Again, the landlord can refuse to rent to all diplomats because, again, not all diplomats are from different countries. So again, if landlords have questions about it, they should consult their own counsel. If they have questions about renting to diplomats. All right, I have one more I want to do quick. This is a court case, C versus K. Okay, C is the licensee, K is a consumer. K worked with the licensee on a transaction, but was unhappy with the licensee's conduct or manner in which they were being treated. So the consumer started a website about working with the licensee. We all know where this is going. The website recited the consumer's opinion of the licensee. The consumer described the transaction, why they were unhappy with the licensee. The consumer claimed that the licensee was unprofessional, unresponsive, lacked negotiating skills, and was the worst real estate broker. Okay. The licensee sued the consumer for libel. The court said, hey, listen, there's no libel. What they said is someone's opinion, right? Unprofessional, unresponsive, lacked negotiating skills, was the worst real estate broker. That's an opinion, right? How do you prove someone's the worst real estate broker? We'd probably have a large number of individuals competing for that honor. But again, they're just opinion, and opinion isn't libel. So the court found that the statements were not actionable. I've gotten this call quite a few times from members regarding third-party services like Yelp or whatnot, where people provide their view on licensees and how well they did in 1 star versus 5 stars. It's a very, very difficult threshold for you to get those removed unless you can prove that the person is actually just lying. If it's opinion related, you're not going to get it removed. Some of the third-party services also have an arbitration mechanism you have to go through to get things removed. They won't just take them down. So again, this is a licensee who didn't like what the consumer is saying about them and tried to sue them, and unfortunately, they just lost miserably. So, okay. I'm going to turn it back over to the folks at Syracuse. I'm going to hang out for a while. Your hour is up, so they're going to go through the procedure to get your CE credit. After that is done and you've filled out the poll, if you want to leave, you can. If you want to stay around, I will be here and I can answer questions on anything else as well.
Anthony, this is Lenore. We've got a questions in the chat that would be beneficial. Would you be able to answer them for everyone, please?
Sure, go ahead.
Okay.
Thank you. Danielle?
Yep. The first one is, can you charge more for security deposit for pets?
So no, technically. What I have seen, and there's no case law about this yet, so I can't tell you if it's legal or not. Landlords have to talk to their attorneys. But some landlords were raising the rent instead. So instead of taking the $5 security deposit for the pet at the onset, they were charging extra $25 a month on the rent for the pet. I don't know if that's legal or not. I haven't seen any case law saying that it's not permitted. But in the same respect, I can't sit there and tell you that it is permitted. But no, they can't charge anything more for a pet. They can't charge a security deposit for a pet.
The next question is, we have a large student housing market. Often the students' financing covers housing and pays for full semester in advance. Is this a violation, or since it is college housing and coming from their tuition, is it acceptable?
Unfortunately, no, it is not. We were hoping that the college matter would be brought up with the seasonal use dwelling unit issue, but it was not. So technically, no, a private landlord would not be able to collect the rent from a college student for the full semester, which is much different than college provided housing, because that's not technically a lease. But if it's off-campus housing, hypothetically, everyone's renting a flat, that landlord can't take the full semester's rent up front.
There was a question about something you were talking about. Is it any different for long-term furnished rentals?
No.
What about short-term student use in university areas?
So we're talking about private landlords renting to college students, not anything that's affiliated with the college, correct, or university?
So,
Yeah, I mean, there's no prohibition against that. The same rules would apply to the Tenant Protection Act as far as what they are.
okay.
What they are doing. So yeah, same thing.
Next question is, does this apply to all rental properties or just seasonal ones?
It applies to all rental properties if they're being used for a seasonal purpose, right? So I think you have to put in the lease that it's a seasonal unit. Nothing says it has to be near a lake or a mountain. There's people are tree peepers maybe will do it during the fall season. But again, it's limited to that 120 days total per calendar year for rental properties.
Perfect, thank you. Regarding fair housing, can you please address how an agent should appropriately answer when asked for demographic composition or websites?
Don't. I know, Mark, I'm making funny, I know. Any reference to any kind of demographics, any kind of socioeconomic status, anything about crime, schools, neighborhood makeup, whether it be race, religion, none of that should be answered by licensees. You can tell the consumer that there are many, many resources available online for them that they can go to find that information if that's something that they wanted to see. But as a licensee, you are not allowed to convey that information to them. What I recommend individuals is, get a sheet with 10 or 12 different sites they can go to on it. Don't just provide them with one, and let them go do their own research on it. But, you use reputable sites, obviously, things that you would also utilize yourself.
Okay. Would an emotional support animal receive the same protection as a service animal? And before you answer that, Anthony, I am going to throw the poll up because I see a lot of people have to go. So I'm going to just throw the poll up really quickly. So while you're answering questions, just fill out the yes in the poll, please. So sorry, would an emotional support animal receive the same protection as a service animal?
So that depends. It's not quite a black and white answer. Again, for a service animal, person has to have a disability. That animal has to help to alleviate some of the signs or symptoms or effects of that disability on the owner. Many individuals with emotional support animals do in fact have a disability. All they would need to get literally is a letter from their healthcare or mental health care provider. That doesn't mean a doctor. That doesn't necessarily mean a psychiatrist or psychologist. It can be someone as a social worker can say that, you know, this person needs an animal. So the bar for that is very, very low. But again, you still need that kind of documentation, unless it's open and obvious why the person has the animal. You still can ask for that documentation. Again, remember, it should come from a medical or mental health care provider. USAServiceDogs.com certificates don't count. Okay. There are all these websites online that you can go and register your service dog and get a vest for them with a badge and a collar and a little red light that spins on top of their head when they're doing things. Right? They're not worth the paper they're printed on. People try to get around the service animal requirement by going to these sham third-party websites and downloading all this information and getting the cards and the vest, and they wave the certificate in the face of the landlord and say, I have a service animal. Well, no, that doesn't mean anything. There's no requirement that service animals even be trained. There's no requirement that they be registered. Now, there are very specialized service animals that do receive training, but not all of them have to receive training. So, like I said, these third-party sites are nothing but a sham. I'm going to tell you flat out. They're just taking people's money and giving them nothing in return but a headache. So again, the threshold is, unless it's open and obvious, if someone has that request, they would have to have a letter from their medical or mental provider.
Thank you. The next question is there a difference between emotional support animals and service animals?
There's also the term assistance animals, and they all get used interchangeably, which is difficult because you even have state and federal governments using different terms to mean the same thing. So it's somewhat problematic. They can be the same thing, but again, it's that does the person have a disability that the use of this animal helps to alleviate part of the disability or the signs and or symptoms. So, disability isn't necessarily something physical, it can be something mental. So there's a blurred line, shall we say. But again, I think you can protect yourself just with the proof of documentation. I thought there was one before that. Hold on a minute. Yes. Can we sign out? No.
Would an emotional support? No, yeah.
No, it jumped on me. That's my bad.
Gotcha.
I can do the next one. What happens if a tenant offers to pay more than 1 month's rent? The landlord cannot accept it. So when I was in law school, I offered my landlord my full tuition toward my rent so that come the end of the semester, I wouldn't be short, because that always happens to most college students. He would not accept it today. If you were to offer it to him, he could not accept it by law. So even if the tenant offers to pay for a full month's or full year's rent up front, the landlord's not able to do that. That we brought this up to the legislature, that this has a chilling effect in fair housing as well, because you have individuals coming from other countries that don't have any credit in the United States. They don't have the means by which to have a credit report run on them. There's no way the landlord can vet them, so to speak. And many individuals come in and say, we'll just pay you the full year up front. And the landlord has to say no. So there is a chilling effect, like I said, on fair housing as far as this is concerned. But the legislature has chose not to take that up at this point.
Perfect. There's some sign outs, but mixed into that, I have one question on the tenant contracts. Is it legal to say no pets allowed?
Sure, you can say no pets allowed, so long as there are no pets allowed, which means that, like anything else with fair housing, you want to make sure that if a landlord has a no pet policy, they really have a no pet policy. It's not just, no pets for the people in this apartment versus the other apartment. You want to apply it universally. And again, no pets do not apply to service animals, so they are exempt from that.
Okay. Dogs for worriers qualify, or is it warriors or worriers? Mike, if you're still here, could you clarify?
Yeah, we're talking about the military dogs. Dogs for warriors.
Okay.
And if that ex-member of the military has a disability that would qualify, that would be permitted. And I can tell you, I know that PTSD qualifies. I know that a lot of veterans suffer from PTSD. So that would be permitted. However, if they didn't have a disability, then it would not qualify, no.
Okay. What if the emotional support or service animal is livestock? So i.e. a pet pig, the landlord has to accept, correct? Any emotional or any service emotional support animal?
There are reasonable limits placed upon that. If I had a studio apartment, I don't think I could have my emotional support yak with me. They're kind of big. But if there's anything other than what I call domesticated animal, or traditional domesticated animal, the landlord need to speak with their attorney about whether or not they could turn it down for whatever reason it happens to be. I don't think the emotional support elephant's popular yet. But you can see, you can see the sliding scale from everything from emotional support hamster to the largest animal on earth. So I think anything outside of traditional domesticated pets, the landlord has to speak with their attorney if they want to deny them.
Why is it such a big deal if rent is paid ahead?
So, since we live north of Poughkeepsie, we're sheltered a little bit. Down in New York City, where the housing market's much, much more aggressive than it is up here, you would have landlords holding tenants hostage. You can't rent this and then you give me an entire year up front. And that's what landlords were requiring. And they were doing it to vulnerable populations, individuals who should be protected, that were not protected. It's different where we have housing that we can find if we need to, as compared to New York City, where you can't find affordable housing. There's no such thing as affordable housing. For every apartment you go to look at, there's 20 people applying to be tenants for that apartment. And the landlords were using that kind of like the Hunger Games. They were, who's going to give me the most up front? And that was it. And they were taking advantage of tenants. And that's why it's there.
Perfect. Do all brokerages have the same SOPs?
No, they wouldn't have to have the same SOPs. I would say the same broker does. So if ABC Realty has 12 branch offices, I think that everyone under that license would have to follow the same SOPs. But ABC Realty in Syracuse and XYZ Realty in Utica, if they're not related at all, they don't have to have the same SOPs. No, it's up to the broker.
Perfect. That officially does it for all of the questions that I can see, and I'm all the way to the bottom. So Lenore, if you would like to come on and end our meeting officially.
Oh, and if anyone has any questions after the fact, don't forget to call the hotline. Liz and I are there all the time. So
Great presentation. And we want to remind everyone that this is recorded, so please encourage your office managers and brokers to repurpose this. All the agents should listen to this presentation, and all the raising the bars that we do bring to our members, we do tape And we edit them a little bit, put them back in the newsletter. And we hope that you take a look again or make sure others in your office do take a look at what we're presenting, because these are high-level presentations. Please make sure that you mark your calendar for the next Raising the Bar, March 16th, and then another community day, May 25th. Ryan McMahon is on deck right now to speak, and the legislative committee will come up with the rest of the lineup at their meeting next week. Also, big shindig at Lakeshore Country Club on June 2nd. We didn't get a chance to have an installation in January, so hopefully we'll make sure that we recognize the presidents, Mark and Andy, and then again, the board of directors on both boards. Atlas has been hired, so we will have some dancing and a lot of fun. And Raising the Bar 4 will be June 29th. We don't have a speaker lined up yet. Sort of want to see what happens between now and then. We know you're going to get really busy, so something might pop up last minute that we want to make sure you all know about. But we try to get the Raising the Bars in at the beginning of the season this year because we know that you're going to have a very active selling season. That's a good thing. Thanks to all of our sponsors and especially to Anthony, Danielle, and Christine. And Andy had a little difficulty with bandwidth, so I took over for him. But thank you, Andy, for today. And remember the legal hotline. Thanks, everyone, and please be safe.